My neighbor Greta filed a claim of prescriptive easement over the shared driveway on the east side of my property on Lexington Avenue in Mansfield 2 weeks after I had posted a no trespassing sign and installed a gate. She said her family had been using the driveway for 40 years and that 40 years of continuous use had established a prescriptive easement that I could not block. She said the easement was hers by operation of law regardless of whether it had ever been recorded. She said I should take down the gate. I did not take down the gate. I am a veterinarian. I want to say something about what the veterinary diagnostic training had taught me and why it is not obvious to apply to a legal dispute. The training had taught me that the presenting symptom and the underlying cause are often different things, and that accepting the first plausible explanation for a symptom leads to incorrect treatment. This habit had been built over 14 years of seeing dogs and cats, and occasionally rabbits and birds, and the more unusual patients that a mixed small animal practice attracts. The habit had not been immediately available to me when the prescriptive easement notice had arrived because the dispute had not felt like a diagnostic situation. It had felt like a threat. The instinct in the face of a legal threat is to react, to find a lawyer immediately and defer the analysis to them. The disciplined response had been to apply the clinical method before finding the lawyer, identify what is actually claimed, identify what elements the claim requires, identify which elements might be absent given the facts I knew, gather evidence before calling the attorney so that the call would be informed rather than panicked. I had spent one evening reading about prescriptive easements in Ohio before I had called Chukwuemeka. I had identified the permission element as the most likely weak point in Greta's claim because I had been told by the prior owner's estate attorney that the families had had an informal arrangement. I had then searched for evidence of that arrangement. I had found the letters. I had called Chukwuemeka with the letters in hand and the analysis largely complete. The clinical method had prepared me for the attorney call. The prepared call had been far more productive than a panicked one would have been. Prepare before you call. The method applies. I also want to say something about the evening I had spent reading about prescriptive easements before calling Chukwuemeka and about what the research had produced. I had started by searching for the basic elements of Ohio prescriptive easement law. Several clear explanations had appeared quickly. The 5-element test had been easy to find. I had then searched specifically for the permission element. How had Ohio courts treated permissive use in prescriptive easement cases? The answers had been consistent. Permissive use completely defeats a prescriptive easement claim in Ohio. A single written permission granted at any point during the claimed period can prevent the prescriptive period from running from that point forward. A permission granted at the beginning of the use prevents the prescriptive period from ever starting. By the time I had finished my research that evening, I had understood that if the Hollenbecks had ever given permission in writing, the case was over. The question had been whether any evidence of written permission existed. That question had led me to the estate attorney. The estate attorney had led me to the box. The box had held the letters. The letters had contained the evidence of permission from the beginning of the use. The evening of research had identified the right question. The right question had found the evidence. The evidence had decided the case. A focused evening of research before calling the attorney is almost always worth doing. Know what you are looking for before you ask for help finding it. One focused evening of research produced the question that led to the evidence. The question had been, does any written evidence of permission exist? The answer had been in the estate files. Know what you are looking for before you call the attorney. The attorney will work better with a client who has identified the right question. I had identified it. Chukwuemeka had confirmed it. The evidence had answered it. A small animal practice in Richland County for 14 years, and I have one habit above all others in diagnostic work. When a patient presents a symptom, I do not accept the owner's interpretation of the symptom as the diagnosis. The symptom is the fact. The interpretation is the hypothesis. The hypothesis requires testing against the actual clinical evidence. Greta had presented me with a symptom, 40 years of driveway use. Her interpretation had been that this use had established a prescriptive easement. I had gone to test the hypothesis against the actual legal evidence. The legal doctrine of prescriptive. I want to explain something more about why the permission element is designed as a complete defense to a prescriptive easement claim and about what this design protects. The prescriptive easement doctrine serves a real and legitimate purpose. It recognizes that long-established patterns of use become practically embedded in how land functions, and that disrupting those patterns after decades can cause genuine hardship. A farmer who has used a lane across a neighbor's field for 50 years to reach a portion of their own land has structured their agricultural operations around that access in ways that cannot easily be reorganized. The doctrine says, when that use has been open, continuous, adverse, and long enough, the law recognizes it as a right. But the adversity requirement is essential to the fairness of this result. The neighbor who uses the lane with the farmer's permission is in a fundamentally different position from the neighbor who uses it without asking. The first has been accommodated. The second has been encroaching. Converting accommodation into a legal right would punish neighborly generosity. It would mean that every landowner who allows a neighbor to cross their property must either never allow it or formally revoke every permission before 21 years pass. The permissive use defense prevents this. It says, neighborly accommodation remains accommodation. It does not become a legal right through the passage of time. Carl had asked for accommodation. The Hollenbecks had given it. The accommodation had remained accommodation. The gate is mine. I also want to say something about how to recognize permissive use in practice and what evidence shows that a use was permissive rather than adverse. The most direct evidence is a written or oral request for permission by the user. If the user asked to use the property, they understood the use was not as of right. Equally direct is a thank you letter or other acknowledgement that the owner was being generous in allowing the use. Less direct, but still probative, is evidence of a general neighborly accommodation, shared access agreements between families that were clearly understood as informal rather than legally binding. The key distinction in Ohio is that a permissive use requires some form of recognition by the user that they were on the property with the owner's consent. A use that the owner simply tolerated without any expression of permission and that the user conducted as though they had a right is more ambiguous and may be characterized as adverse rather than permissive. The clearest cases are the ones with written evidence of the permission. Carl had written his permission requests on paper and had thanked the Hollenbecks for the courtesy in writing. The written evidence had made the case unambiguous. If your situation involves a neighbor who has been using your property with your family's informal permission for years, document that permission in writing now. Write a letter, send an email, create a record that shows the permissive character of the use while the arrangement is ongoing. Do not wait until the neighbor files a prescriptive claim. Document the permission while the arrangement is ongoing. Do not rely on oral understandings alone. A single signed letter saying this is a courtesy and not a right is worth more than 20 years of assumed understanding. Assumed understandings disappear when the people who held them die. Written evidence survives them. The Hollenbecks had not written the permission. Carl had written the request. Carl's writing had been enough. The written permission is the insurance policy for neighborly accommodation. It costs one letter. It protects against a prescriptive easement claim for as long as the letter survives. Write it. Keep it. Give it to the estate. Neighborly accommodation is worth protecting. The Hollenbecks had given accommodation for decades. Carl had acknowledged it. The acknowledgement had protected their successors. It protected me. Easement in Ohio requires that 5 elements be established by clear and convincing evidence. The use must be open and notorious, continuous for the prescriptive period of 21 years, adverse or hostile to the owner's interest, under a claim of right, and without the owner's permission. Every element must be established. The absence of any one element defeats the claim. The element that ends most prescriptive easement claims when the evidence is examined carefully is the permission element. Use that is I want to say something about what I now advise other property owners to do when a neighbor makes a prescriptive easement claim about a use that predates the current owner's period of ownership. The key question in any prescriptive easement case is whether the use was adverse or permissive throughout the claimed period. If any part of the claimed period involved permissive use, the adversity element is defeated for that period, and the prescriptive period must start over from the end of the permission. If the use began with permission, it began without adversity, and the prescriptive clock never started. To find this evidence when you are not the original owner, contact prior owners if they are still accessible and ask them directly about any arrangement they had with the neighbor. If prior owners have died, contact their estates or their estate attorneys. Estate attorneys often retain files for years after the administration closes. Those files often contain correspondence with neighbors about shared arrangements. Look in the property sale records for any disclosure about neighbor arrangements. Look at any files that may have been conveyed with the property. The evidence of permission is often in papers that no one has read for decades because no one had expected to need them. The estate attorney had retained the papers. The papers had held the evidence. The evidence had defeated the claim. Search for the papers. They may be there. If they are there, they may end the case before it begins in earnest. The letters had ended mine before the argument phase had started. I also want to say something about the general principle that emerges from this case about the value of old records in property disputes and about why property owners should maintain correspondence with neighbors about shared arrangements. Every time a neighbor asks to cross your property, use your driveway, run a utility line, or share any access arrangement, you should respond in writing if you agree to it. A simple letter or email saying, "I am happy to allow you to use the driveway on an informal basis at my pleasure, and this arrangement is a personal accommodation and does not create any permanent easement or other legal right. Keep a copy." Ask the neighbor to acknowledge the arrangement in writing. Carl had naturally acknowledged the permissive character of the arrangement in his letters because he had been a person who understood he was receiving a favor and had expressed his gratitude accordingly. Not every neighbor who is using your property informally will do this naturally. Some will simply use and not express any acknowledgement. Those are the cases where your written documentation of the permissive character becomes essential. Document the permission when you give it. Keep the documentation for as long as the use continues and longer. If you sell the property, give the file to the buyer and to your real estate attorney and the estate. The file may be needed by someone you have not yet met. Patricia Achebe had kept the file. The file had protected her client's successor's property. Keep the file. Write the permission down. Keep the copy. Tell the estate attorney to keep it. This is the specific advice that comes from this case. A file of neighbor correspondence is a title protection document. Treat it that way. Patricia had treated it that way instinctively. I do now deliberately. The habit of keeping neighbor correspondence is the habit that protects the properties of future owners who do not yet know they will need it. The specific advice from this case is also the general advice for any property arrangement between neighbors. Write it down and keep the writing. Not because you distrust your neighbor, because your neighbor is mortal and their successors may not share their understanding. Greta may have genuinely believed she had a right. The letters said otherwise. Carl's understanding had been different from Greta's. The letters showed Carl's understanding. Permissive cannot establish a prescriptive easement no matter how long it continues. A permissive use is the opposite of an adverse use. A permissive use is a use that the owner has allowed. An allowed use does not ripen into a legal right through the passage of time. The law does not reward a neighbor who was given permission by converting that permission into an easement at the neighbor's convenience. I had not been the original owner of the Lexington Avenue property. I had purchased it 6 years before from an estate. The prior owners had been the Hollenbeck family, who had owned the property for 38 years before the estate sale. I had searched the Richland County Recorder's portal and had found no recorded easement over my driveway. I had then asked the estate attorney, who was still accessible, whether she had any records from the Hollenbeck estate. She had been organized and had forwarded me a box of papers she had retained from the administration. In that box were 3 letters from Greta's father Carl to the Hollenbeck family. The first letter was from 33 years ago. It asked permission to use the driveway to access the garage at the rear of Greta's property because Greta's father was having difficulty maneuvering his truck around the corner from the street. The second letter was from 22 years ago. It renewed the request to continue using the driveway. The third letter was from 15 years ago. It thanked the Hollenbecks for their continued courtesy in allowing the use of the driveway. Before I go on, if this story, I want to say something about Mansfield and about Richland County and about what it means to build a veterinary practice in a county with both urban and agricultural character. Richland County has the specific mixed character of an Ohio county, where the county seat is a mid-sized city with industrial and healthcare and service employment, and where the surrounding townships have the agricultural and residential character of the Ohio interior. The animal population reflects this mix. Urban companion animals in the city neighborhoods, farm animals in the outlying townships, working dogs and horses, and the occasional exotic animal that the agricultural economy produces. A mixed small animal practice in a county like this sees a range of patients and client situations that a purely urban or purely rural practice does not. I had come to Richland County after a residency and had stayed because the practice opportunity had matched exactly what I had trained for: diverse caseload, established community, a county where animal care is taken seriously both as companion care and as agricultural necessity. The home clinic annex at Lexington Avenue had extended my reach into the eastern residential neighborhoods and the townships east of the city. The driveway case had been a direct threat to that extension and to the clients who depended on the accessibility it provided. Winning the case had protected not only my property rights, but my ability to practice in the way I had built my practice to function. Richland County had given me a professional home. The case had protected that home. I also want to say something about what Mansfield has given me as a professional home and why I had chosen to build my practice in a mid-sized Ohio city rather than in a larger market. Veterinary practice in a community where you become known over time produces a quality of professional relationship that is not available in markets with more turnover. I have clients whose animals I have treated for their entire lives and whose owners I have seen through the full arc of a companion animal's life: puppy visits, annual exams, illness, treatment, the final appointment that is the hardest part of the work. In Richland County, I have had the same clients across multiple animal relationships. They return after the loss with new animals, and the continuity of the relationship matters to both of us. This is not possible in the same way in a larger market with more competition and more client mobility. The Lexington Avenue property had extended this relationship quality into the east residential neighborhoods through the home clinic annex. The clients who walked their animals to the carriage house clinic from the surrounding streets had a relationship with the practice that was rooted in proximity and consistency. The prescriptive easement case had threatened that rooted quality. The letters had protected it. The ruling had confirmed it. Richland County has been good to my practice. 14 years of good work in a good community. The gate protects what those 14 years have built. Richland County has given me 14 years of professional relationships that I value above any credential or achievement. The Lexington Avenue property had deepened those relationships by extending my reach into the east residential neighborhoods. The case had protected that extension. The law had protected the case. The letters had protected the law's ability to work correctly. All three had worked together. The practice continues. The practice and the community and the property had all been protected by the same 3 letters. 3 letters from a courteous man to courteous neighbors. None of them had intended legal significance. All of them had had it. This is often how decisive evidence works. It was created for a different purpose and becomes essential for a purpose no one anticipated. Keep the letters, all of them. Connects with something real in your life. Please take a moment to like and subscribe, but only if you genuinely feel it. Drop a comment and tell me where you are watching from and what time it is there. I read every single one. My name is Imani. I am 46 years old. And this is the story of how 3 letters from Greta's father to the prior owners of my property established that every year of driveway use had been permissive, and what an attorney named Chukwuemeka Osei, who had been practicing property and easement law in Richland County for 12 years, did with those letters when Greta brought her prescriptive easement claim. Now let me explain why the permission I want to say something about the carriage house and about what it had meant to find a property with a rear structure suited to a home clinic annex. Veterinary practice in a mixed residential and agricultural county like Richland requires a combination of clinical facilities at a primary location and accessibility for clients in the outlying areas who cannot easily reach the primary clinic. I had maintained the main clinic at a commercial location near the downtown and had wanted a home annex for early morning and evening appointments for established clients. The carriage house at the back of Lexington Avenue had been exactly the right structure, large enough for an examination table, a treatment counter, and a small kennel area, with existing plumbing from the workshop conversion that had required only modest additional work to bring up to clinic standard. The driveway on the east side had been the access route. Clients pulled in from Lexington Avenue, drove back to the carriage house, parked in the small area behind it. When Greta had claimed a prescriptive easement over the driveway, she had been claiming a permanent right over the primary access to the portion of my property where I practiced. The gate had not been a fence dispute. It had been a practice viability dispute. Blocking Greta's claimed easement had been necessary for my ability to use my own property for the purpose I had purchased it for. The case had been more than a neighbor argument. It had been a professional necessity. The letters had resolved it. I also want to say something about the clinical work and about what the home annex had produced over the 6 years I had been using it. The Carriage House Clinic had become the part of my practice that I valued most specifically. It served the established clients who had been with me for years and who appreciated the convenience of an early morning appointment close to their homes in the East residential neighborhoods. I had a roster of elderly clients who could not easily drive to the main clinic downtown and for whom the Lexington Avenue location had been the difference between accessing veterinary care and not accessing it. An aged cat with a chronic thyroid condition whose owner did not drive. A pair of dogs whose human was in a wheelchair and for whom the home clinic annex was the only viable access point. 3 families in the surrounding blocks who had chosen my practice specifically because the annex was within walking distance. When Greta had tried to establish a prescriptive easement over the driveway, the practical stakes had included these patients and their owners. Losing the right to gate the driveway would have compromised the clinic function that served the clients who needed it most. The letters had protected not only the property, but the practice relationships built over 6 years of appointments in the carriage house. The gate protects access for the clients who depend on it. The court protected the gate. The elderly clients who walk their animals to the carriage house clinic have continued to do so. The gate controls access in the way it was designed to control it. The practice functions the way it was designed to function. 14 years of practice built on the relationships that proximity and consistency produce. The gate protects those relationships. The court protected the gate. Both hold. The practice has grown since the ruling. 3 new clients in the East residential neighborhoods have found the annex and have become regular patients. The gate controls the access. The access serves the clients. The clients trust the practice. The practice was worth protecting. It was protected. The veterinary method and the legal system had both worked correctly. Element defeats a prescriptive easement claim and about why the design of the doctrine makes this result correct. A prescriptive easement is, at its core, an adverse claim. It is a claim by a non-owner that their use of someone else's property has been so persistent and open and hostile that the law should recognize it as a legal right. The doctrine exists because neighbors sometimes establish patterns of use that landowners acquiesce to for long periods and that become practically embedded in how the land functions. The law balances the claims of the owner against the claims of the long-term user by requiring both duration and adversity. The duration requirement alone is not enough. The use must also have been hostile to the owner's interest. A use that the owner permits is not hostile to the owner's interest. It is the opposite. It is a use the owner has invited or sanctioned. There is nothing adverse about using property with permission. The person who has permission to use a driveway is not in the same position as the person who has seized the driveway without permission. The law does not treat them the same way. The permissive user gets no prescriptive rights no matter how long the permission lasts. The practical reason for this design, I want to describe what Chukwuemeka Osei had said when I showed him the 3 letters and about his assessment of their evidentiary significance. He had read all 3 carefully. He had been quiet for a moment after reading the 3rd letter, the explicit thank you. He had said, "This 3rd letter is the most valuable piece of property evidence you are likely to find in a prescriptive easement case." He had said, "It is Carl in his own handwriting in his own words saying that the Hollenbecks had been courteous enough to allow the use." He had said, "Courtesy and allowance are the language of permission. They are the antonyms of adverse and hostile." A court that reads this letter cannot find that the use it describes was hostile to the Hollenbecks' interest. He had said that the first 2 letters were equally valuable because they showed the pattern. Carl had requested permission at the beginning of the use and had renewed the request after years of accommodation. The use that followed each request had been a use made after obtaining permission. Use made after obtaining permission is permissive by definition. He had said, "We will file these as exhibits and the answer will write itself." He had been right. The answer had been direct. The exhibits had told the story. The court had read the story and had reached the only available conclusion. 40 years of permissive use is not a prescriptive easement. It is 40 years of accommodation that had been courteously given and courteously received, and that had not created any legal rights for the recipient. The law had protected the courteous Hollenbeck successors. I am their successor. The gate holds. I also want to say something about what Chukwuemeka had said after the ruling about the value of the third letter in particular, and about why explicit acknowledgments of courtesy are such strong permissive use evidence. He had said, "The reason the third letter is so powerful is that it was written after years of use, not at the beginning. A letter asking for initial permission establishes that the first use was permissive. A letter renewing the request establishes that the permission was understood as ongoing and required renewal. But a thank you letter written 15 years before the hearing establishes that at that specific point in the claim period, the user understood the use was by the owner's grace. It is contemporaneous evidence from the middle of the claim period that the adversity element was absent at that time. Once adversity is absent at any point during the period, the continuous 21-year period of adverse use has been broken. The prescriptive clock stops. It cannot have run continuously from a period when the use was acknowledged as permissive." He had said, "The three letters together cover the entire period of claimed use. Permission at the beginning, permission renewed, permission acknowledged in the middle." The prescriptive clock had never started because it had been stopped by permission from the first day of the use, Carl had asked. The Hollenbecks had given. The use had been permissive from day one. The gate was always mine. The three letters together made the case unambiguous. One letter might have been argued as isolated. Three letters spanning 18 years form a pattern. The pattern said, "This use was understood as permissive from the beginning and continuously throughout." Chukwuemeka had said the pattern was the key. A single data point is a curiosity. 3 data points spanning 18 years is a finding. The finding had decided the case. Carl had been a courteous man, and his courtesy had protected my property after his death. He had not intended this. He had only intended to express his gratitude to his neighbors. But the expression of gratitude had been the legal evidence that had decided the case. Courtesy expressed in writing has a longer useful life than courtesy felt in the moment. Carl had expressed his. The court had read it. The gate holds. Is important. If permissive use could ripen into a prescriptive easement after 21 years, every landowner would be required to either grant no permissions at all or to formally revoke every permission before the 21-year period ran. Neighbors could not share driveways informally. Farmers could not allow adjacent owners to cross their land as a neighborly accommodation without risk that the accommodation would become a permanent legal obligation. The law prevents this by making permissive use definitively non-prescriptive. A permission that is in writing is particularly strong evidence of the permissive character of the use because it shows contemporaneous acknowledgement by the user that they were using the property with the owner's consent. Chukwuemeka reviewed the 3 letters I want to describe the moment I had read the 3 letters in the estate attorney's email and about what the diagnostic shift had felt like. I had been at my desk in the home clinic at the back of the Lexington Avenue property when the email had arrived. I had been between appointments. I had opened the attachment. The first letter had been a single handwritten page on plain paper in a careful but informal hand. Carl to the Hollenbecks. Dear Howard and Ruth. He had explained that he was having difficulty maneuvering his truck around the corner from Lexington Avenue and asked if it would be acceptable for him to use their drive to reach his garage at the back. He had said he hoped it would not be an inconvenience and that he would be grateful for their accommodation. I had read the second letter. Carl again, a renewal of the request, noting that Howard and Ruth had been kind enough to allow the use previously and asking if the arrangement might continue. I had read the third letter, a handwritten thank you on the same plain paper. He had written that he was grateful for their continued courtesy in allowing the use of the drive and that he hoped he was not imposing. I had sat for a moment with the 3 letters on the screen. In clinical work, the moment when the laboratory results change, the working diagnosis has a specific quality. The presenting picture that had seemed one thing becomes clearly another thing. The presenting picture had been 40 years of driveway use. The laboratory result had been 3 letters. The diagnosis had changed completely. 40 years of permissive use. Not adverse, not hostile, permissive. The prescriptive easement claim had no foundation. I had called Chukwuemeka the next morning with the 3 letters already identified and understood. The case had been made before we had spoken. I also want to say something about the estate attorney Patricia Achebi and about what her professional habit of retaining files had meant for this case. She had administered the Hollenbeck estate 6 years before. Most estate administrations generate correspondence and documents that are relevant only during the administration and that most attorneys would not retain afterward. She had retained them. She had called me back within 2 hours. She had scanned the relevant documents the same afternoon. The letters had arrived in my inbox before the end of the workday. The speed of the response had been possible only because the files were organized and retained. Many estate attorneys would have shredded the files years before I called. Patricia had not. Her professional habit of organization and retention had produced the evidence that had ended the case. When I had thanked her after the ruling, she had said, "I never throw away neighbor correspondence. You never know what boundary or easement or access question will come up later." She had been right. 18 years later, the correspondence had mattered. It had mattered completely. Her retention habit had protected my property. The files had been there because she had kept them. She had kept them because she had known that neighbor correspondence has a long, useful life in property matters. She had been right. I am grateful. The gate is up because she kept Carl's letters. Patricia Achebe is the reason the case was won. Not only Chukwuemeka, not only me. Her professional retention habit had produced the decisive evidence. If those files had been shredded 3 years after the estate closed, the case would have been far more difficult. I had sent her a note after the ruling. She had said, "I keep everything." She was right to. I do now too. Retain neighbor correspondence. Ask estate attorneys to retain it. Tell your real estate attorney when you sell. The box that Patricia kept had been just a box of old papers until the moment it was the most important box in Richland County. Old papers have a way of becoming the most important box in a property dispute. Keep the box, and said, "This is the clearest permissive use evidence I have seen in a prescriptive easement case." He said the letters were significant for 2 specific reasons. The first was that they had been written by Greta's father, not by an attorney, which meant they were spontaneous expressions of the actual understanding between the families rather than lawyerly formulations. The second was that the letters spanned 30 years. The first request for permission, the renewal of the request, and the thank you letter explicitly acknowledging the Hollenbeck's courtesy. The third letter in particular, the explicit thank you for the continued courtesy, was a contemporaneous acknowledgement that the use was permissive and not adverse. It was exactly the kind of evidence courts find dispositive on the permission question. Chukwuemeka filed the answer to Greta's prescriptive easement claim, attaching the 3 letters as exhibits. He argued that the letters established that every year of the driveway use had been permissive and that a permissive use cannot establish a prescriptive easement regardless of duration. He argued that Greta's own father had twice written to the Hollenbecks to request permission and had once written to thank them for it, and that these letters were direct evidence that the use had been understood by the user himself as permissive throughout the period in question. The Richland County Court of Common. I want to say something about the hearing before Judge Adaora Obi and about the moment when she had read the 3rd letter aloud in court. She had been reading through the exhibits as part of her review and had selected the 3rd letter to read aloud because it was the most explicit. She had read it in its entirety. Carl thanking Howard and Ruth for their continued courtesy in allowing the use of their drive and expressing hope that he was not imposing. When she had finished reading it, she had looked up and had said, "Counsel for the claimant, how do you reconcile this letter with the adversity requirement?" Greta's attorney had argued that the letter predated a later period of use that had been adverse. Judge Obi had asked what evidence existed of the later period of adverse use. The attorney had said the use had continued after the letter was written. She had said, "Continuation of a permissive use does not convert it to adverse use. A permissive use remains permissive until the permission is clearly revoked and a new period of adverse use begins. There is no evidence before me that the permission was ever revoked or that a new period of adverse use began." She had then denied the claim. The hearing had been direct and precise. She had identified the critical question, read the critical evidence, and followed the law to the only available result. The clinical evidence had been the letters. The diagnosis had been correct. The treatment had been the ruling. The gate stays up. I also want to say something about what the hearing had been like as an experience and about what it means to sit in a courtroom and hear the evidence read aloud by a judge. I had been in the courtroom for the hearing with Chukwuemeka at the plaintiff's table. Greta had been at the defense table with her attorney. Judge Obi had come in and had settled the papers and had begun to read through the exhibits quietly before speaking. When she had picked up the 3rd letter and had read it aloud, I had watched Greta's face. She had known the letters existed from the time Chukwuemeka had filed them as exhibits. She had had weeks to consider what they meant. But hearing her father's handwritten thank you read aloud in a courtroom by a judge, who then asked how its language was consistent with a claim of adverse use, had been a different experience from reading it privately. I had not felt satisfaction in that moment. I had felt something closer to sadness. Carl had been a courteous neighbor. His courtesy had been genuine and had been genuinely received. His letters had been the letters of a person who valued the relationship with his neighbors. None of that had been in conflict with the legal conclusion that his use had been permissive. It had been both things at once, a genuine neighborly accommodation and legally permissive use that could not become a prescriptive easement. The law and the human relationship had both been what they were. The gate stays up. The relationship with Greta is complicated. Both things are true. The law held both. Greta had known about the letters before the hearing. She had had weeks to consider them. The case had proceeded nonetheless. I do not know whether she had known about them before Chukwuemeka had filed them as exhibits. Whether she had known or not had not changed the legal analysis. The letters said what they said regardless of anyone's knowledge of them. The facts had been the facts. The law had applied the facts. The result had followed. Please assign the matter to Judge Adaora Obi, who had been handling civil and property matters in Richland County for 11 years. She reviewed the letters and the prescriptive easement elements. She found that the letters established permissive use from at least 33 years before the hearing, and that a permissive use cannot be the foundation of a prescriptive easement claim. She noted that the third letter, which explicitly thanked the prior owners for their courtesy in allowing the use, was a contemporaneous acknowledgement of permission that was directly inconsistent with the adverse and hostile use required for a prescriptive easement. She denied Greta's claim. She found that the driveway was my exclusive property and that Greta had no easement of any kind over it. She sustained my right to maintain the gate. I want to say something before I go. I want to end with something about the gate and about what it represents now that the litigation is over. I had installed the gate because I had needed to control access to the driveway that led to my clinic annex. A gate on a driveway used by veterinary clients is not purely symbolic. It controls when clients arrive and when they leave, and whether the space behind the carriage house is occupied when a new client arrives. The gate had served a practical function before the legal dispute, and it continues to serve that function after it. What has changed is that the right to maintain the gate has been confirmed by a court. Greta knows that her prescriptive easement claim has been examined on the merits and denied. She cannot refile the same claim based on the same facts. The denial is final. The gate represents not only my right to control access to my driveway, but the principle that neighborly accommodation does not become a legal obligation through the passage of time. The Hollenbecks had been courteous neighbors for decades. Their courtesy had been received with appreciation by Carl, as his thank you letter had shown. That courtesy had not created a permanent legal right for Greta or for Carl or for anyone who came after them. It had been courtesy, and it had remained courtesy, and the law had said it was courtesy and not easement. The gate is up, the practice is open, the clients come in off Lexington Avenue and drive back to the carriage house and park in the small area behind it and bring their animals in for examination. This is what the property was purchased to do. The diagnostic method had preserved this function. The law had confirmed it. Read the letters, test the diagnosis. The gate holds, the practice continues. Both will. I also want to end with something about the diagnostic method and about why I have come to believe it applies more broadly than the clinic. In veterinary work, the diagnostic method saves animals. An incorrect diagnosis leads to incorrect treatment, and incorrect treatment leads to harm. The method exists because the stakes are real and because the correct answer is available if you test the interpretation against the evidence rather than accepting the first plausible explanation. In the prescriptive easement case, the stakes had also been real. My practice, my clients, my property. The method had been the same. Identify the claim, identify the elements required, identify the weak element, gather evidence bearing on the weak element, present the evidence to the appropriate authority. The evidence had been the letters. The authority had been Judge Obo. The result had been correct and had been based on evidence rather than on whose claim had been stated more forcefully or whose attorney had argued more impressively. Evidence-based results are reliable results. They are based on what actually happened rather than on what someone claims happened. Carl had asked for permission. He had received it. He had thanked for it. These are facts in the record. The facts had produced the result. The gate is up. The practice runs. The animals get their care. The method works. It works in the clinic. It works in the courtroom. Test the diagnosis. Find the evidence. Trust the evidence. The evidence is the truth. The truth holds. It held here. It will hold. The method is available to anyone willing to apply it. Find the claim. Find the elements. Find the weak element. Find the evidence. Apply the evidence. The evidence decides. This is what clinical training had given me. A method that works wherever the facts are. The facts and the law applies the facts. The gate is the result of applying the method. The method is available to you. Apply it. The facts are out there. Find them. Not about Greta and not about whether she had known about her father's letters. About the diagnostic method and about what it had produced in this situation. Greta had presented me with a symptom and an interpretation. The symptom had been 40 years of use. The interpretation had been prescriptive easement. The clinical method had been to test the interpretation against the evidence rather than to accept it. The evidence had been in the box of papers from the estate attorney. The evidence had said the use had been permissive the entire time. The hypothesis had not survived the test. The clinical finding had been that no prescriptive easement existed because the use had been permissive from the beginning, and permissive use is the negation of the prescriptive easement claim. The gate stays up. The driveway is mine. The diagnostic method works in a veterinary clinic and it works in a property dispute. The principle is the same. Test the interpretation against the actual evidence before you accept it as the diagnosis. Thank you for staying until the end. I want to describe what the Richland County Recorder portal shows for the property on Lexington Avenue and what the instrument history includes now. The portal shows the original deed by which the Hollenbecks had purchased the property 38 years before the estate sale. It shows the estate deed conveying the property to me 6 years ago. It does not show any recorded easement over the driveway because no such easement was ever recorded. A prescriptive easement, if established, would exist regardless of whether it was recorded, because prescriptive easements are established by court ruling rather than by recording. But the absence of any recorded easement in the index had been the first relevant fact. The recorder held nothing supporting Greta's claim. What the recorder now also holds is the court's judgment denying the prescriptive easement claim and confirming my exclusive ownership of the driveway. That judgment is now in the index. Any future title search will find it. Any future owner will know that the driveway was challenged and that the challenge was denied. The judgment protects my buyer's title when I eventually sell. It protects the property from a relitigation of the same claim by Greta or her successors. The court's determination is in the public record. The driveway is mine. The record says so permanently. The letters had produced the ruling. The ruling is in the recorder. The recorder holds the truth. Anyone who searches can read it. I also want to say something about what the recorder judgment means for my future sale of the property and about why recording the court's denial of the easement claim is valuable in the long run. A prescriptive easement claim that has been litigated and denied is a resolved cloud on title. A future title examiner who encounters the record of the litigation will also find the court's judgment denying the claim. The judgment is a permanent answer to the question of whether a prescriptive easement exists over the driveway. The answer is no. The answer is in the public record. The answer was produced by a court that reviewed the evidence on the merits and found that the use had been permissive throughout the claimed period. Future buyers will not need to investigate this question themselves. The question has been investigated. The answer is recorded. Title insurance will be available without exception for an easement that has been judicially determined not to exist. The litigation had been an expense and a disruption. It had also permanently resolved a cloud on title that might otherwise have deterred buyers or required negotiation at every future sale. The judgment is in the recorder. The recorder holds the resolution. Future owners of the Lexington Avenue property will benefit from it. The letters produce the judgment. The judgment protects the property forward in time. The carriage house clinic is accessible. The driveway is clear. The record confirms both. The recorder judgment is specific to the facts of this case. Carl's use, the Hollenbeck's permission, the 3 letters. It cannot be used to prevent a genuinely adverse use claim that is not based on the same facts. But it does prevent Greta from relitigating the same claim based on the same facts. The claim was examined, the claim was denied, The driveway is mine. This determination is final on these facts. Anyone who owns property adjacent to land that has been subject to informal access arrangements should search the recorder for any recorded easement first. If none exists, search for evidence of permission in old correspondence. The recorder and the estate files together hold most of the relevant facts. Both are accessible. Use them. I had used both. The recorder had shown no recorded easement. The estate files had shown the permission. Together, they had decided the case. If this story made you feel something, write it in the comments. I read every single one. And if you want to hear the story of a farmer whose neighbor claimed a prescriptive easement over a field path that had been used for hiking, and what the posted signs and the annual written permissions established about the permissive character of that use, it is waiting for you in the description below. Click it. Until next time, take care of yourselves. And if a neighbor claims a prescriptive easement over your property based on long use, before you accept that claim, search for evidence of permission. Look in old letters. Look in estate records, look in notes between prior owners, a single written request for permission, a single thank you letter acknowledging the owner's courtesy, a single document showing the user understood they were on the property with permission rather than as of right. Any of these can defeat a prescriptive easement claim no matter how many years the use continued. The evidence is often in the papers no one thought to save. The estate attorney had saved them. The box had been there. The letters had been in it. The gate is still up. I want to tell you more about Mansfield and about Richland County and about the property on Lexington Avenue and what it had meant to find a house with room for a home practice annex when I had been looking for somewhere to settle after graduate school. Mansfield is the county seat of Richland County in north-central Ohio, south of Lake Erie, and north of Columbus, a mid-sized city with the manufacturing and agricultural heritage of the Ohio interior. The city had been a center for steel production and related industries through much of the 20th century and has the specific character of a city that knows its industrial history and that has built a community identity around the institutions and neighborhoods that history produced. The downtown has a restored historic district, and the residential neighborhoods spread outward from it into the hills and agricultural areas that give the county its specific landscape quality. Lexington Avenue is in one of the established residential streets in the East Residential neighborhood, a well-kept block of substantial older homes with the deep lots and mature trees that decades of continuous occupancy produce. I had bought the Lexington Avenue property specifically because of the accessory structure at the back of the lot, a former carriage house that had been converted to a workshop and that had the square footage and the utilities to support a small examination room and a treatment area for a home-based annex to my primary clinic. The property arrangement had been exactly what I had been looking for. Main house, deep lot, rear structure, good access from the street. The driveway on the east side of the property ran the full depth of the lot from Lexington Avenue to the carriage house and was how I accessed the rear structure daily. When Greta had tried to establish a prescriptive easement over it, she had been attempting to establish a permanent right over the primary access route to the portion of my property where I practiced. I want to say something about the diagnostic method and about what the veterinary training had given me and about why the habit of testing the interpretation against the evidence had been the specific skill the situation required. In clinical veterinary work, a presenting symptom can have many explanations, and the wrong explanation leads to the wrong treatment. A dog presenting with lethargy might be hypothyroid, might be anemic, might be in pain from an undetected injury, might be suffering from a systemic infection. The owner's interpretation of the symptom is useful context, but it is not the diagnosis. The diagnosis comes from testing. You run the blood work, you do the physical examination, you take the history carefully. You arrive at the diagnosis from the evidence, not from the first interpretation that seems plausible. The habit of not accepting the first plausible interpretation as the correct one had been built into me across 14 years of clinical work. When Greta had said 40 years of use equals prescriptive easement, I had not accepted this as the diagnosis. I had run the tests, searched the recorder for any recorded easement, contacted the estate attorney for the prior owner's records, found the letters. The letters had changed the diagnosis entirely. The symptom, 40 years of use, had remained the same. The correct diagnosis, permissive use defeats the prescriptive easement claim, had required testing. I want to say something about the box of papers from the estate attorney and about what finding the letters had felt like. The estate attorney had been a woman named Patricia Achebe who had administered the Hollenbeck estate 6 years before and who had retained the administrative files as a matter of professional practice. When I had called her and explained what I was looking for, she had been immediately helpful. She had said she would check the files and had called me back within 2 hours. She had said, "I have correspondence between the Hollenbecks and their neighbors about shared property matters." She had scanned the relevant documents and had sent them to me by email that afternoon. When I had opened the email and read the 3 letters from Greta's father, Carl, I had understood immediately what they meant. I had understood it the way you understand a laboratory result that changes the working diagnosis. A moment of clarity where the pieces that had been ambiguous resolve into a clear clinical picture. Greta had been using the driveway for decades. Her father had asked for permission. The permission had been given. The use had been permissive throughout. The permission had converted what might otherwise have been an adverse use into an expressly allowed one. The prescriptive easement claim had no foundation from the day it was filed. I want to say something about what Chukwuemeka Osei had told me about how often old correspondence and estate records defeat prescriptive easement claims and about why this kind of evidence is frequently decisive. He had said that prescriptive easement cases often come down to the permission question, and that the permission question is almost always resolved by evidence that predates the dispute. Neighbors who have shared property informally for decades often have a record of that sharing in old letters, notes, cards, informal agreements written on paper and left in files that no one has looked at for 30 years. An explicit request for permission is decisive because it demonstrates that the user understood their use was not as of right. A renewal of the permission request is equally decisive because it shows the understanding persisted over time. A thank you letter acknowledging the owner's courtesy is, as he had put it, the clearest possible evidence of permissive use because it is the user's own contemporaneous statement that they were on the property by grace of the owner and not by right. He had said that in 15 years of property practice, he had seen several cases where exactly this kind of old correspondence had ended a prescriptive easement claim that would otherwise have been difficult to defeat on the merits. The evidence is in the papers. The papers are often in estate files. If you are dealing with a prescriptive easement claim involving a prior owner's period of use, contact the prior owners or their estate.